be seated. Good afternoon. Welcome to the First Court of Appeals. We have one case on today's submission document, oral argument submission document. Case number 01230036CV, H.R. Martin County Landfill, LLC, and the Railroad Commission of Texas versus John W. Mabee et al. May I have the appearance of counsel, please, for the appellants?
Good afternoon, Your Honor. Sarah Ferris of the Office of Attorney General on behalf of the Railroad Commission.
Good afternoon, Joe Sanders on behalf of the applicant, H.R. Martin.
And you're dividing your time?
We are, Your Honor.
Yes, Your Honor. I'll be having, Mr. Sanders will be having 4 minutes of time, and of my time I'm going to reserve 4 for rebuttal.
And for the appellee?
Jane Weber, together with Ola Kobzar, we represent the Mabee parties, but I will be presenting argument on behalf of all of the appellees, including the Kelton and Johnston parties.
Good afternoon, Colonel Walker, on behalf of the Kelton and Johnston parties.
Thank you very much. Which one of you is going first? And you may proceed.
And Your Honor, the clock says 16, but I'm only going to use 12 at the beginning. May it please the Court. This appeal involves a suit for judicial review of the Railroad Commission's final order approving a stationary treatment facility permit for H.R. Martin. The Commission approved H.R. Martin's application for a permit related to the disposal of non-hazardous oil and gas waste into line pits at the Martin County facility. The District Court provided a single basis for reversing the Commission's order approving H.R. Martin's permit. The Court finds that the Railroad Commission's approval of H.R. Martin's permit application is based, in part, on information outside of the administrative record with no input from Commission technical staff or opportunity for protesting parties to respond to such information. Respectfully, the District Court is wrong. The Commission lawfully issued its final order, and I'm going to explain why. First, I'm going to explain about the basis for the agency order and how the Court reviews it.
Before you get there, do you understand the trial court's order to be based on substantial evidence, due process, or both? How do you read the trial court's order and the parameters of it for our analysis?
Your Honor, I read the Court's decision to be based on the APA 2001.174, which sets out the standard of review for reviewing agency orders, and it requires that there be a substantial evidence in the record of the reliable and probative record as a whole. Second, I also address the Commission, how the Commission acted lawfully through its final order approving the permit based upon the record before them. Turning to my first point, Texas courts make clear that the basis for agency orders are to be set out in the order itself. Courts judge the agency order on the basis on which it purports to rest, and the mental processes of individual commissioners are immaterial to judicial review. That's the Texas Utilities case. There must be a reasonable basis for the order and a clear connection between the final decision and the Commission's rule. That's the Occidental Permian case. The Commission's order in this case meets these standards. The Commission's 10-page order includes findings of fact that provide a reasonable basis for the decision and demonstrates a clear connection with Statewide Rule 8. Statewide Rule 8 does 2 things. Do not waste oil and gas resources, and do not pollute the groundwater or surface water. Near the end of the 66 findings of fact and findings of fact, the Commission addresses head-on in ultimate findings of fact the Statewide Rule 8.
What is the requirements for the relationship between the permit applied for and the permit approved? Because it seems here that we have a disjunction between what Martin initially asked for and what the RRC ultimately approved.
In the administrative process, once a permit is to be heard on is contested. You go to a contested case hearing where there's can be discovery conducted, there's evidence put in the record, there's testimony, there's post-hearing arguments, those things. The commission makes a decision based on the record. The commission has discretion to make changes to the permit itself, because what the permit does is literally permit the company to operate. So they have a duty.
So what legal guidance do we have setting out the guidelines for the relationship between the application and the permit that's ultimately issued? I mean, you can't apply for something in the San Jacinto River and then have a permit issued for something in the Guadalupe River. So what guides us in determining how far the commission can vary from the application?
Well, two things, Your Honor. First, it has to fall within the call of the hearing, right? It has to fall within the notice. What was noticed to be, what was contested. So it has to fall within there. And second, the commission has to reach ultimate findings and make conclusions of law on the question before them. They have to ensure that the terms of statewide Rule 8 are satisfied.
Well, but that's the crux, right? What were those issues before the commission? And I'm speaking specifically about the 3 conditions, because that's the crux of the matter. Were those specific conditions before the commission when the commission approved the permit and entered its findings of fact and conclusions of law? So when those conditions were imposed, was that based on evidence that was contested at the case hearing and subsequently at the open meeting before the commission?
Yes, Your Honor, it was based on the record before the commission, and the evidentiary record specifically. There was 14 days of hearing. There was 99 exhibits to look at, including a 1,500-page application. The application included cross-sectional diagrams of the liner system, included descriptions of the liner system, and let's be clear that the 3 additional conditions that were added, they were added after the commission found that the application is approved. They were not a condition of approving the permit. And they're based on the record.
Where are
Was it
you
approved?
basing that on? I'm sorry.
We're both asking the same question.
Okay. Yes, Your Honor. In the order, if we look at the ordering provisions, first of all, well, let's start with the findings of fact. The 3 ultimate findings of fact are 63, 64, and 65, and they echo the statewide Rule 8 requirements. After those findings, there's a finding of fact regarding additional requirements that the applicant was not adverse to. Then, if we look at the ordering provisions, in the ordering provisions, the first paragraph says, "It is ordered that H.R. Martin County landfill application for a permit to operate a commercial oil and gas waste stationary treatment facility is approved." Then the second paragraph, it orders that once the order is final, which we have to allow for time for motions for rehearing, once it's ordered, it orders technical staff to issue the permit. And then after it's ordered them to issue the permit, it added the 3 conditions. Plus, if you look at the edited conditions themselves,
What do you mean, days later or later in the same document?
in the same document.
All right, so that all at once. I don't think we can sort of, something has to be printed first, because so it seems it would be simultaneous that the conditions were part of the final order.
But that's not the only thing we have, Your Honor. We also have the conclusions of law. There's a conclusion of law that actually specifically addresses the additional conditions. It talks about what demonstrates that the water won't be polluted. It says the application and the additional requirements demonstrate that the water won't be polluted. The conclusion of Law 4, which follows conclusion of Law 3, says that the application meets the requirements of statewide Rule 8, the application. Not the application plus, the application does. So that's
How
what
do you
important.
read, okay, back up, because I want to make sure I understand what you're saying.
Yes.
One of the issues, and at least it appears that you're contesting that the conclusion was that the application with the additional requirements is what premised the decision to approve the permit. Is it your position that conclusion of Law 4 by itself, without the conditions, to you suggest that the permit would have been approved absent those conditions?
Yes, Your Honor, but even if that weren't so, there's still evidence in the record that supports the additional conditions. First of all, we know that the courts are to presume
Okay,
that
well,
the...
this is not making sense then.
Okay.
That if the commission approves the application as it was submitted, but now Martin is required somehow to do the application as submitted plus these other things, why did Martin volunteer to include these other provisions or amendments?
Because there was a proposal to deny the application.
But you just, so was there a proposal to deny it? Was it in the air? Was the approval of the application contingent upon these other conditions?
I don't believe that's the case, Your Honor. We know that the commission is not bound by the proposal for decision at all. They have total discretion on whether to accept or reject or do so in part its own hearing examiner's proposal.
Okay,
Even before so.
Accept or reject.
Or modify.
Or do it in part or modify, but what constrains the extent of the the analogy that crosses my mind is trial by consent, right? When the trial court is entering a judgment, it has to track the pleadings. It can't sort of enter a judgment on something that wasn't in the initial pleadings. So if you analogize the initial pleadings to the initial application, and now the trial judge which would be the commission, is entering an order on something that wasn't contested by one of the parties. The other party didn't have an opportunity to contest.
But, Your Honor, that's not the case. The other side had the opportunity to contest the liner system, the placement of where they are, what the requirement should be, whether the compatibility depends on the type of liner. They even cross-examined witnesses asking if, in it like another permit, if there should be a condition in this case where staff pre-approves or vets the type of liner to be used. And smartly, the applicant said, we're not averse to these things. These are additional protections, we're fine. That doesn't mean that the order was contingent upon them. But even so, there is substantial evidence in the record that supports what the commission did. The conditions extended the already litigated liners into further places, up a temporary berm and underneath a drying pad, but those liners were already litigated. And then as far as the details of the GCL liner go, again, applicant cross-examined parties saying, would it be inappropriate or unreasonable to have staff determine which the specific liner should be, and they said, no, it would be reasonable and appropriate. And that was also in their closing arguments as well. Then there's other...
You said this issue was litigated. Can you specify where it was litigated in the
Yes,
record?
I mean, Your Honor, there's quite a... And also counsel for H.R. Martin can as well, but I can give you some for instances.
And I mean, not just that the issue was heard by the court, but also that the landowners had a chance to say why extending the liner would be insufficient to protect the groundwater.
Your Honor, and before the Railroad Commission, parties have discovery rights and they have the opportunity to use those. They have the right to cross-examine, and the applicant did so. They even cross-examined on some of the permits, and they, like I said, they cross-examined an expert witness on one of the very terms that is in there
But
now.
how do you cross-examine on documents and specifications and designs that have not been presented, prepared, or reviewed? It's sort of guessing at what something may look like.
But that's what discovery is for, Your Honor, and they didn't engage in that. They could have developed a record more themselves. But it's not the only case we've done that.
But hold on a second, because the discovery would allow them to discover information provided before the case hearing. The conditions were imposed after the permit were approved. These are things to come in the future.
But there was evidence on the GCL liner, and there was a cross-sections in the record. That is evidence that the order can rely upon to do so. And for leaving details, other cases do that as well. We know that the Maverick County case does that, the Browning-Ferris versus Johnson case, sorry, Your Honor, the North Alamo 1 case, these are all cited in my brief. There are, for instance, in the TCEQ versus Maverick County case from 2022, TCEQ had a permit application in front of them with complete blanks in the application for boron limits, and there was nothing about aluminum monitoring. And they set conditions that allowed for those limits to be set after the permit's issued. And, Your Honor, we know that from case law we can trust professional staff, and we ask the court to affirm.
I know you're out of time, but I do have one question that I think is important. Do these conditions require further approval by the department or agency in order to be then implemented?
Your Honor, thank you for asking that. That is a key question. No, it does not, and that's what makes the order final. It's not a condition precedent for the order to be final, and there is no further approval process. When it used the word approval there, it was in the compliance phase where they sign off to make sure that it's the appropriate one. And it's the classic enforcement activity that's done post-decision in permits.
Thank you.
Thank you.
May it please the court. On behalf of the applicant, HR Martin County Landfill, I had 2 points I'd like to make today, the first of which we have already delved deep into, so let me get right to it. The question that's being posed is, did the protestants have an opportunity to litigate these additional protective measures that were ordered as part of the final order? The answer to that question is yes. Before we get to how we achieve that answer, we have to first understand what is the relevant legal framework. The relevant legal framework is, does the body of the evidentiary record support the decision? The decision is the facility will protect the groundwater. Okay, so if the body of the evidentiary record supports that decision, then the commission's order must be upheld. And so my first point is, these additional environmental protections that were ordered by the commission were extensions of existing elements of the initial facility design. These elements were part of the initial application. They were vetted by the technical permitting staff, and they were subject to the hearing. If you take, for example, the requirement to extend the liner system to the interior berms, to match the exterior liner system. Those words alone tell us that the liner system itself and its adequacy to protect the groundwater was at issue in the permit and at issue in the hearing. Specifically, the landfill itself is a giant cell. It has an exterior berm. The initial facility design had...
What do we do with the proposal for decision?
Nothing. The
Just
proposal for the
completely ignore
decision was authored by commission staff, but ultimately the commission's decision-making rests entirely with the commission. And there's case law that's...
Correct. So if you're a protestant, right, and you see the proposal for decision, you realize that's what you need to counter. That's sort of the baseline that you're arguing from. The proposal for decision says, you know, that the soils are not suited for oil and gas waste management and disposal activities. But it seems like it's almost a bait and switch that this is the proposal for decision, this is the application, and now here's something else entirely which we're going to issue that's being approved. I mean, it just seems like it's shadow boxing, bait and switch, or, you know, sure you would have beaten that team, but you wouldn't beat this other team, therefore you lose.
I don't know that it's bait and switch at all, because the commission is free to ignore the PFD entirely. The commission in this case was free to grant the permit without the additional requirements, and there was substantial evidence on all the points supporting the ultimate finding that the groundwater would be protected. In response to concerns raised by the protestants, the commission ordered additional protective measures that my client agreed it would undertake. My client firmly
And did
believes.
the protestants ever have the opportunity to say those additional measures are not going to be enough?
Absolutely, and that's what I was going to get to in my first
Okay, well,
point.
that's the-
So the exterior berm is double lined. The initial, and that's been part of the facility for the whole time. The initial facility design had the interior berm, which is temporary, only single lined. And so during the hearing, they questioned the adequacy of the single liner to protect the groundwater. But also during the hearing, they had the opportunity to assail the adequacy of the double liner as a groundwater protection element. And they chose not to. That's a tactical decision. That double liner system was diagrammed, it was in the evidence, they had every opportunity to attack its adequacy as a groundwater protection element during the hearing. What happened after the hearing, and may I finish the answer? I'm out of time.
Yes.
What happened after the hearing is the commission says, okay, this has been demonstrated to my satisfaction as an element of this facility that is protective of the groundwater. I'm going to order that it be extended to another part of the facility to match the proposed element. And in doing so, made the facility more protected. And that, my second point was just going to be, I think that the district court's judgment should be reversed because it disincentivizes behavior we should encourage. Because my client agreed to these additional protective measures for a safer and more environmentally protective facility, and it should not lose its permit as a consequence. Thank you.
Any further questions? Ms. Weber, you may have an additional 3 minutes.
Thank you, Your Honor. This administrative appeal comes to this court in a slightly unusual posture because process really is the issue. And after lengthy evidentiary proceeding with hundreds and hundreds of pages of technical application, lots of lengthy technical engineering, geology evidence, the Railroad Commission rejected the 90-page proposal for decision that was issued by the hearings examiners who actually heard that evidence. And they approved the oil field waste facility permit with the 3 additional conditions that had not been part of that lengthy process. That was, the permit applied for was not the permit that was granted. And when analyzing so the district court reversed because of that mismatch, because we did not have the opportunity to probe that. And when this court is reviewing that decision, that order, context matters. The application and the proposed disposal facility presents a confluence of highly technical design and engineering, highly toxic oil field waste, and a very shallow outcrop of the Ogallala Aquifer within its recharge zone that is the sole source of fresh water for the Panhandle.
Let me ask you what we asked your learned colleague. Is this a due process complaint or a lack of substantial evidence complaint?
I think it is both of those things together because it was a bait and switch. We did not have the opportunity to present these things at the hearing. And
how do we parlay those together then? Because we have to analyze them separately.
I think it's exactly what the district court articulated. Is what happened is the commissioners looked to evidence that was outside the administrative record and relied, at least in part, on evidence outside the administrative record in approving this subject to the 3 conditions. And I'm going to say that it is extraordinarily splitting hairs to say that the 3 conditions are not part of what the commission was actually granting. But in terms of was there evidence that supported these? Was this actually litigated? And I think that's kind of where the horse is buried here. I am going to emphatically disagree with the argument by Mr. Sanders that yes, there was record evidence of it. And what I'd like to do is point to a couple of days ago.
I'm sorry, before you move on to the evidence, can I ask you, how would you articulate the test for our due process analysis based on decided authority, so that we can see that through the umbrella of your continuing argument. I'd like to understand the parameters of it.
Your Honor, I don't think the court needs to view it in terms per se as a due process argument. Because due process, I think, might be more of a chainsaw rather than a scalpel, when what is presented to this court is a scalpel. Yes, there was evidence regarding Liner, but there wasn't evidence regarding the conditions that the court did. And so I think that it's a question of looking beyond the call, beyond the notice of the hearing, looking beyond the changing the permit that was granted based on evidence outside of the record. And so the exhibits that were filed, the oral argument exhibits that H.R. Martin filed a couple of days ago, I think are super helpful in illustrating what was not the subject of the hearing, how the conditions were not the subject of the hearing. First condition, no one's fighting about that the staff has to approve the actual GCL line. We're not fighting about that. We're fighting about number 2 and number 3.
I'm sorry, so 1 is not an issue then?
1 is not an issue. No one's quarreling with that. That's fine. But number 2 and number 3 are looking out, making assumptions. It's a stacking of inferences and assumptions.
Ms. Weber, but then I find that more complicated. If 1 is not an issue, do you agree then with Mr. Sanders' statement that presumably by extending the liner, there was already a finding and a litigated issue that the liner itself was sufficient as presented during the commission's hearing or the contested case hearing?
That absolutely glosses over some of the engineering technicalities here, and here's why. The issue isn't, is this a good liner? Not all liners are the same in this facility because they serve different purposes and they sit in different places and they present different needs. Well, first of all, GCL, it's a geoengineered clay layer. It's a manufactured product. It's basically like what's inside a diaper, the kind of gel inside a diaper that soaks up moisture. Let's talk about condition number 2, which is the lining of the temporary berm. That's exhibit number 3 that Mr. Sanders filed, and it shows a schematic of a temporary berm that's next to, at the border of one cell N1 to cell S1. And there's the temporary berm, and under the original application, the GCL liner was going to end at that dotted line. And our complaint wasn't, but wait a minute, and then there's a little temporary berm. Our complaint was not, well, you need to extend the liner to go up the interior there. Our complaint was, having a temporary berm there is a terrible design because all of the waste can just spill over, and then when you go to open up the next cell and stack the waste, that's going to get excavated, and so you need to abandon temporary berms entirely. And that is what we argued. That appears at Administrative Record 39, pages 36 through 37, is our discussion of the temporary berms are a bad idea, get rid of them.
But the inverse of that, the commissioner was free to reject your argument.
Yes, that's true.
And to adopt the argument of H.R. Martin.
Well, but H.R. Martin never argued that, let's put this, but what I want to talk about is how the engineering, this isn't just, extend the tarp a little further down the roof. Because when you extend the liner up just one side of the temporary berm, there's an extraordinarily important and technical aspect of how do you anchor it. How do you anchor? You don't just extend it and then, oh, there it is, and we drive some tent stakes. The anchoring of the GCL liner into the soil is its own whole set of engineering technical challenge, and that is nowhere addressed. It was never addressed as any part of the it wasn't part of the permit, it wasn't the application, it wasn't part of the call, it wasn't something that we litigated, and yet it is something that could lead to catastrophic seepage because it's where the liner ends, how it is sealed, how it is attached. It raises a number of issues to prevent seepage. How is it going to anchor? Will it be removed when the next cell is opened up? How will it be removed? Because excavating it, how is that going to prevent any of the materials on it from seeping in? Will that create a break in the GCL layer if you cut it off to take away the temporary berm, which is what their design calls for? But if you don't create a break and you leave the temporary berm there, then it makes the thing smaller. In other words, this all matters. All of these technical aspects.
But what also matters is the question. According to Mr. Sanders, you had the opportunity to present that evidence and to cross-examine on that and to question this in the administrative hearing.
But that wasn't the permit applied for. That wasn't the design of the permit. That was not the specs. They have the burden.
So the permit applied for did not include this temporary landfill berm that we see in 3. Correct?
It includes a temporary landfill berm, but it didn't include any of the specs of how do you line it and how do you deal with it after the fact. And that was the condition, and it matters. And the same is true of condition number 3. And if anything, condition number 3 presents sort of an even more complicated case, because condition number 2 says, and H.R. Martin went, at the end of the day, they have to come and they have to show some specs to the commission.
Right, so if we follow the engineering and we follow your argument that these are indeed material things that need to be litigated and evidence should be heard on, how do we square that with, there is a paucity of precedent on this, the North Alamo case and I guess the Ur case on that, which was Walker Creek, with regard to how much leeway the commission has and the administrative agency has to go beyond the application?
Well, Your Honor, there is a limit, and it is fact specific. And I believe that in this facility that is highly technical, and this threat, if someone has made a mistake, if there's an error somewhere, it is truly existential. This is the sole source of fresh water for all of the Panhandle. And if there is an error in the efficacy of how this is anchored and how that temporary berm is removed, or how it is fitted under the drying pads, which I'd be happy to talk about further, if there is an error there is no remedy after the fact that can fix it. So I think what we have here, what makes this different from some of those cases, is the highly technical engineering aspect of the changes that the commission made. It's not just like I'm going to move this.
So how would we distinguish this from North Alamo? We don't have the privilege of the access to the administrative record in this 1992 opinion, but
well,
it's about a 3 feet water table. How can we authoritatively state that this is a more important issue?
Well, I don't think you need to get to more important. I think you can rest your hat on more technical. I think on 2 things. First, more technical. This is technical engineering. You look at the nature of the application, the hundreds and hundreds of pages of specs and engineering drawings, and every bit of all of this is so highly engineered. There were 15 days of evidence presented, and almost all of it was from experts on highly technical issues. So that is one difference. And a second difference is these are conditions being imposed as part of the permit. These are part of the permit. It is extraordinarily splitting hairs. It's not just in the same document, it's the very next paragraph. The very next paragraph that imposes these. The commission's conclusion of law says the application with these conditions will protect the
But
groundwater.
But the agency has the discretion to impose additional conditions.
They do.
And so I hear what you're saying, and I understand it. It is a highly technical issue, and this is someone's drinking water that we're worried about. But the bottom line is these issues were contested and were litigated, and I know there's a nuance, and I hear you, and I understand what you're saying it, but where do you draw the line? Like, at what point in time is this issue litigated? At some point, the commission heard the evidence and they can impose additional conditions. Are we saying, and if we agree with you, are we saying a precedent that the commission itself cannot impose additional protective measures because they're always going to be subject to further hearing? And is that...
No, Your Honor, I don't think that. I think that if I were your law clerk and I were tasked with drafting this opinion, then what I would do is talk about the evidence that was actually presented at the contested case hearing, how the evidence followed the application, how the new conditions were never the subject, the new conditions were not the subject of the hearing because of these particular technical engineering reasons. And while the commission has extraordinary discretion to exercise its expertise, it does not have, what Ms. Ferris said, total discretion to disregard what the proposal for decision and the fact findings and the evidence provides. They do not have total discretion. And here we have the fact that this is potentially existential for the entire panhandle of Texas is what makes this case important. But it's not that doesn't change what the law provides. The law provides that we are entitled to litigate the application and the call of the hearing, and we were denied that. And the commission bypassed the process. In a case like this where you have super technical and you have super high stakes, process matters.
I think now you're making it sound like a due process problem and not a substantial evidence problem.
I don't want to pigeonhole this case because I think it fits like it is both of those things.
I understand, but we, in writing it, have to treat them discreetly.
I don't think you need to treat them discreetly, Your Honor, because this case presents exactly what it is. The law does not require you to do like this in the same way that the law does not require the commission to do like this. You may look at the whole record. You may look at all of the circumstances. But what's very important here is process. It's what I said right at first. This case presents an issue, a question of the propriety of the process. And where you have super technical and where you have super high stakes, it is important to observe the procedures because those are the safeguards. That's the bulwark. Listen to the evidence. Don't skip over the technical experts. Don't brush aside, don't rest on assumptions, and that's what happened here. And if I may, I can give let me talk about the condition number 3 because I think it gives a very good example. Condition number 3 is the one that says, please put underneath the drying pads the same kind of liner that exists under the receiving pit. And it doesn't say, and you have to give submit additional schematics. Well, 3 days after this order came out, Railroad Commission technical staff sent an email. This is an administrative record 53. 3 days after the final order was issued, Commission technical staff sent an email to the hearing staff and said, wait a minute, condition number 3, that needs to also say that they need to submit some drawings and specifications. And hearing staff said, no, it's just going to stay as it is. So there's not even, when confronted with condition number 3, the technical staff who were going to be charged with reviewing this said, wait a minute, we need some drawings. We don't know how this is going to work. No, we're going to blow that off. And here's why that's important. There's more than one sort of liner at issue here in this 89-acre facility because there are a bunch of different moving parts. And a liner that may be appropriate for this kind of pond may not be appropriate for that kind of pad.
Did you make that argument? Did your clients make that argument? They had every opportunity to make that argument at the contested case hearing. To dispute that the GCLs were proper, either for the as shown or as a whole for this facility.
Well, Your Honor, here's what it is. So if you look at exhibit number 1, I'm lying to you, exhibit number 2. Exhibit number 2 has these cross sections of what the liners are. The GCL is one very, very small component part of this liner. This liner it has a lot of different components. It's 7 feet. It's 7 feet. A layer of this, a layer of that, a layer of this, a layer of that, a layer of this. And what condition 3 says, take that one, stick it underneath the drying pads. Well, this lining here is what's provided for the landfill contact stormwater pond. A 7-foot stack, I can't even reach 7 feet, a 7-foot stack of these particular items may be perfectly appropriate for the stormwater runoff, for being underneath a pond that holds stormwater runoff. But if you put it under the drying pads, and what the drying pads are 3 very, very large pads, because a lot of this, when this waste comes in, it's liquid. And so it comes in on trucks and they put it on these drying pads so it'll dry out, and then they start stacking it, and that's where in the cells with the temporary berms. And the design calls for 2 feet of this and that and this and that, and then 2 feet of concrete. And so what condition number 3 says is stick these 7 feet down underneath the 2 feet of concrete. Well, it didn't even say that. It says underneath.
You disagree with the decision, with the conditions, but our standard is more limited in reviewing the decision of the commission, and this is where we're having the difficulty, right? Even if we agree with you, our standard of review does not allow us to revisit those findings of the commission the way that you're asking us to do so.
But the finding of the condition is unsupported by the evidence. There was nothing that tells us, A, whether this stack of 7 feet of liner is appropriate, can fit, can work, can do its job under those drying pads that are topped by 2, and
So
it was
let me
never
ask
the
you-
source. And that is not, it is, what's not appropriate is to require us to assume a different permit, a different design facility, because all of this has to fit together. These are not it's little, it's like just because GCL liners were discussed, so now you can do anything about a GCL liner. You could have litigated GCL liners. It's like a Lego. It's like Legos. I got a box of Legos. Yeah, we talked about Legos.
Okay,
That
so
doesn't mean I can make a Millennium Falcon out of this box of Legos. And that's the problem, is that the commission, what H.R. Martin would have this court do is say, oh, here was a discussion about a liner, and so that means it was litigated and it's okay to put it under here.
If the commission had just granted the permit without the conditions, would we even be here?
Yes, because we think that even without that, we could make this is not supported by substantial evidence because of, and against the backdrop of all this, is the significant fact that there is no naturally occurring clay barrier under this facility, and that was proved in the crucible of the adversarial proceeding. H.R. Martin's application was conditioned on the fact that this naturally occurring barrier existed. Mother Nature put a barrier there. They told the commission Mother Nature put a barrier there. Because of that representation to the commission, this was administratively approved, and it even went to hearing. But for that misrepresentation in the application, it wouldn't even have been a hearing. And only because we were given the opportunity to present an expert case on that, on something that we knew was on the table, which is the key. We didn't know that this 7-foot set underneath these concrete pads was part of what was on the table, because Justice Kelly, the permit applied for was not the permit that was granted. These things are super technical, and the fact that the moving parts are changed makes it a different design, makes it a different permit. And for that reason, the district court gave the modest relief of go back and let us do something about these conditions. When given the opportunity to cross-examine the technical aspect, we proved that an enormous part of their application was a complete lie.
So is the question that we have to answer, following your logic, is there substantial evidence to support the permit with the conditions, or is there substantial evidence to support the permit even without them?
We don't have to win your second question. We only have to win your first question, because that is the final order that the commission gave. And that is based, at least in part, on evidence that is outside the record, in the form of assumptions. And if, again...
Okay, that was my next question. What is the evidence outside the record that you believe, or the trial court believed, was considered?
Well, Your Honor, that this 7-foot set of lining can be placed underneath the drying pads, and that will protect groundwater, because that's the prime directive. That's the prime directive, the statutory standard. Does this protect groundwater? And the fact that you have to excavate down and excavate down and excavate down and add this extra 7 feet of liner when you're only 35 feet above the top of the aquifer to begin with. And top of the aquifer is not static. Just, it's up, it's down. It's up, it's down, because that's just the nature. That is how nature works. And the one that is exhibit number 1 shows that's showing from the top, and it shows the cement, the drying pad that's next to the cells. And there is not evidence that of the exact depth as of that date of the top of the aquifer under the concrete pads. So the evidence that H.R. Martin points to is the top of another area that's kind of nearby, closology. It's closology. But if you look at the elevations, even just on this exhibit, there's a 20-foot swing. And so the idea that, oh, we can just dig 7 feet down and that'll be fine. We don't know that. We're assuming that. But if you look at page 7 of our brief, has a demonstrative that shows a cross-section, a subsurface. And it demonstrates that in the 8-year period from 2011 to 2019, the top of the aquifer moved 23 feet. This facility is going to be there forever. Forever. And so for excavating down an extra 7 feet under the concrete pad, under the 2 feet of concrete under the drying pads, for that to have efficacy, that aquifer can't, the top of the aquifer can't move and get closer. But we know that it does.
Why cannot the staff of the commission evaluate these schematics and designs that are going to be submitted that will have these specific requirements in place?
Because condition number...
Instead, we have to defer to the expertise of the staff. Why can't the commission then defer to the expertise of the staff in reviewing these design revisions?
I have about 5 responses to that. One is, that's what the commissioner should have done, is defer to the experts in this staff. 2, there's nothing in condition number 3 that requires them, H.R. Martin, to give schematics about that design. That's what the staff asked for in AR 53. Please have them do more designs. Give me more designs. And no, they didn't. 3rd, while the commission has awesome technical staff, they won't necessarily always get it right. For example, they accepted H.R. Martin's representation at the get-go that there was a naturally occurring clay barrier down below. The technical staff approved that, and it turns out that was false. And 4th, we don't have an opportunity when that happens, when H.R. Martin comes in, down the line, or its successor who it sold the permit to, or whoever, comes in down the line and says, okay, now we're fixing to build, we don't have an opportunity then to come forward and challenge that. And there's not a contested case opportunity at that point. So that's why, those are among the reasons. That's why we have to get this right at the front end. Because if any of those assumptions are wrong, and it all boils down to, it's what makes this different from North Alamo, which makes this different from the Brown and Ferris case, is that this is a highly technical, highly engineered facility. And with moving parts, not all the parts fit together exactly perfectly. The relief here is modest. Let's go back and figure out if these conditions are workable. Let us challenge and probe and test these conditions 2 and 3, just like we tested the existence of the naturally occurring barrier. If they'd have done that, if the commission had done that at the time, or if H.R. Martin had accepted the district court's ruling, we'd be done by now. Probably there would already have been it would have been reopened. The commission would have established the parameters of the call of testing. So here's what the evidence is without it. Let us test it. It is a small, modest bit of relief, and it's something that I think this court can distinguish, can cabin its ruling because of the highly technical nature of the application. Because if it is not, if Ms. Ferris is correct that the commission has total discretion, then you just throw the APA out the window. Then agency, whatever, there's no review. There's no judicial review. It doesn't really matter.
Do you have any further questions? Thank you, Ms. Barry. You may proceed, Ms. Ferris, and you'll get an extra 6 minutes should you decide to use it.
Thank you, Your Honor. To immediately clarify the last statement, we never argued that the commission has total discretion to disregard the APA. The commission's order follows the APA, including 2001.141, which sets out that it must have findings and conclusions based on the evidence. Second, what it does have total discretion on is whether to accept or disregard its own employee's proposal. And that's what the commission did. And it included in the order the reasons why. But I also want to talk quickly about the evidence. Remember that these additional requirements are the result of the contested case process. There was 14 days of hearing and 99 exhibits and lots of cross-examination in this case. Some of the evidence we have, for instance, Administrative Record 181 at 112 and 113, Mr. Schroeder, which is an expert witness for the applicant, discussed GCL additives for specific applications and confirmed that proper GCL will be selected for the site based on both engineering properties and compatibility with operating environment. AR 174 at 110 through 112, expert witness Mr. Belling testified that properly selected GCLs can be superior to natural clay and lack of natural confining layer can be engineered around. Mr. Schroeder had also testified that the GCL is the equivalent of 2 feet of clay and said that the GCL has porosity standards that exceed the solid waste manual. And the proposal for decision said that if the proper GCL is chosen, that standard will be met as well.
Ms. Ferris, does the commission have total discretion to determine whether a further hearing is required after the imposition of some pretty new conditions?
Yes, Your Honor, that's where that decision lies. The case law is clear that you're only entitled to 1 hearing. In fact, there are some cases like the Rana decision where you don't even have a hearing. But when you have a contested case hearing and the issues were within the notice of that hearing, in this case they were, then you're not entitled to a second bite. We understand that the protesters sincerely desire to be able to look over staff's shoulder and test the efficacy of what staff decides. But that's not their role, and we know the Natural Resource Code says so. Natural Resource Code 85.13 says only employees of the state have this enforcement authority. And Chapter 91 says the commission has the enforcement authority over its orders, its permits, and the rules. And that's exactly what the commission did, was delegate to staff. And we know we can trust staff. We know that from by the way, the Browning-Ferris case, the North Alamo case, the Exxon cases, these aren't simple matters. Those are also highly technical decisions. Protesters described in their brief, the Exxon case is involving just moving something 100 feet. Well, those are well density decisions. That's a highly technical matter, and it matters because you are prevented by the rules from wasting oil and gas resources, and that reservoir can be affected. In this case, that's one of the requirements of statewide Rule 8 as well.
There is, in those cases, and this is my reading, and please correct me if I'm wrong, some of the decisions that were made were based on the evidence that had been presented in those contested case hearings. For example, the one that you're referencing, moving the additional well 100 feet, those issues were litigated, and there was some testimony that had been offered about the proper placement of that well, the replacement well in that case.
Yes.
How do you respond to Ms. Weber's dispute that this issue was litigated, that these additional schematics that would show the 7-foot layering that she's describing underneath for the condition number 3, for example, that those present different issues that were not really litigated, that yes, they litigated the adequacy of the lining system, but now the placement and the anchoring that would be involved as it concerns condition number 2 and number 3.
Your Honor, a couple of things. First, where those are placed, there's already evidence that can be used, not direct, but inference, right? We have other places in the facility that had concrete above it, and that there would be like the receiving pits. So when we say we're going to use the same lining system under the drying pits as we used over here, we can look to that evidence, right? But also, we can trust our professional staff.
Speaking hypothetically, where is the evidence, and where were they given the opportunity to contest it?
I'm sorry? The evidence was presented over 14 days in the contested case hearing. They cross-examined witnesses. There was witnesses put on by the application.
Well, Ms. Weber raised a very specific example, which Justice Rivas-Molloy was referring to, about, say, the anchoring. Where was that raised?
Where was it raised, Your Honor?
Where was it presented?
Okay.
Where were the protestants given an opportunity to contest that evidence? According to Ms. Weber, that there was nothing talking about the adequacy of the anchoring as set forth of the layer as set forth in Exhibit number 3. Where in the record was this presented? Just talk about the anchoring, because that's a specific example before us right now. Where was that presented in the commission hearing, and where did the protestants have an opportunity to contest, cross-examine, put in their own evidence?
I don't have a pinpoint site on the anchors, but I can tell you generally where it is. In AR 90 and 91, those are the 2 application notebooks. And AR 91 has pages and pages of diagrams and information on leakage rates and on the HDPE liners, and I believe there is a diagram on the anchors, Your Honor. And there's also a description of the system in AR 90. But there's also, I believe, applicant in their briefing went through and provided evidentiary sites for each of the additional conditions. But also, there's one other thing. Your Honor, these additional conditions were added as a result of the hearing and as a result of the arguments made by the protesters. The commission listened and they added conditions. And we know from the Personal Care Products versus Smith case.
Okay, well, so that might be persuasive if the protestants said, we want this, Exhibit 3, we want this added. And I didn't see anywhere in the record where they said, we want this Exhibit 3 added. It seems like it was come out without necessarily their input.
Well, Your Honor, in their closing arguments, they advocated for, first of all, the ALJs in the hearing, there was discussion about what additional permit conditions could there be, and they allowed the parties to address that in their closing arguments. The protesters did that, and in I believe it's AR 39, they said that one of the conditions they would want to see is linings under different parts of the system.
Right, so they
The
said
commission-
we need further lining.
Yes.
And then did H.R. Martin then come forward with a proposal to put that lighting with proper anchoring? And then the protestants have the opportunity to say, no, that anchoring isn't good enough?
Your Honor, those specifics on how it's carried out have been left to professional staff. It's a compliance matter.
Who the commission could just disregard.
The commission is the technical expert, not its staff, first of
You're
all.
just talking about the staff, and so
Right.
I'm trying to sort out the
Right. So the-
process. He's making a
The
decision.
commission had all of this in front of them. The arguments of the parties about whether the liner system would be enough. And by the way, the HDPE liner, there was always at least a single layer of that. But whether the protections are enough, given the circumstances of this particular facility. And the commission made those decisions. In conclusion of law, they said the statewide Rule 8 is satisfied. The application satisfies that.
We
So when
understand
they
that's the ultimate
listen,
conclusion, but what we're saying is that wasn't supported by the evidence, and that the protestants weren't given proper process to prevent them from reaching that decision.
but it was, Your Honor, it was supported by all the testimony on the other portions of the facility and about the liner themselves. It's in AR 90 and 91. It's in the cross-examination and direct testimony and rebuttal testimony of the witnesses. 181, 176, 174, 169 are the primary ones that I would point to. And
Ms. Ferris, can you walk me through? So once these new designs and schematics are submitted, I think you were explaining that your technical staff would then review them. Is there an approval process? Who gets to determine whether these are appropriate and will protect the aquifer? And based on these second and third conditions that were implemented?
just like in other terms in this permit, the technical staff makes that decision. There are other terms within this permit that call for technical staff to approve something before installation or before operation or before closing. The technical staff has that used as that enforcement authority to ensure that the statewide Rule 8 is satisfied, and that the terms of the orders are met, and that the terms of the permit are also met. And that's what we trust staff to do. Browning Ferris tells us that, and North Alamo tells us that.
If the staff determines that these drawings or designs are not compliant, what happens then?
The staff has the authority to deny them operation. And that's within the permit itself, Your Honor. And the commission acted lawfully through its final order, making findings of fact supported by the record evidence and deciding the essential matters, including statewide Rule 8 is satisfied, and approving the application. And the commission established a rational connection between the order and statewide Rule 8, and we would ask the court to affirm.
Thank you. Obviously, the court had some specific questions. We're not instructing you to file a post-submission briefing, but if you do, get it here by next Wednesday and limit it to 5,000 words. And if there's a reply to that, we can reply to 2,500 words and get it here following Monday. It would be, I think, the 21st. Case number 01230036 CV is now submitted, and the First Court of Appeals is now adjourned.
All right.